I'm already registered.
I actually haven't registered. I really should do that.
How you doing?
Doing well. Good to see you.
Good to see you. Yeah.
How are you?
I'm good. I'm good. How are you?
Very well. Thank you again for that letter.
Oh, you're very welcome.
It worked its magic.
Oh, I mean, you know, didn't really do anything. You just kind of repeat.
Oh, no, you did. I read it and I was like, oh. I showed it to Ralph and I was like, he said really nice things about me. I got a reference letter for the AAA.
Okay. Yeah.
Say that, just so, you know.
When we circulate it
Exactly.
every few years.
That's
to
right.
watch.
That's right.
Oh, perfect. So Paul's not going to make it. He's apparently sick.
Oh no.
Oh, is that right? Okay.
So it's just they change the constant change.
Really? Yeah. I mean, I never had to really talk up between us. I was hoping Paul was going to fill the time.
Who's logging?
Talk about, right?
Children in the mediation or
Yeah.
something.
Always take questions.
That's true. I'm not sure I'll be able to answer.
What do I do? Make something up. Say it with confidence. Helen, how you doing?
Good, how are you?
I'm good.
They're actually having a rap for local lawyers as well. Make sure I'm not.
Super. Thank you.
Is it? Oh. Yes. Well, they just start getting like kind of, but I'm doing this. Oh, no. That's, I had to write that kind of like more like. Hello. Oh, sorry. How are you doing? I'm doing well. I haven't seen you. I know it's been a while.
Yeah. Karen. Yeah, Leslie. Yeah, I can't remember where we met.
I think we actually had one of them.
Yes. Do you want all three mics for Helen? We need one, if there's one. So I'll keep one over here. I'll do you on my corner.
Okay.
And we'll have two.
So I can just plant
Oh,
here
and
for
we'll only need 3 chairs. We got 1 sick.
Oh, okay. Is that cool?
Something.
It's bad. It's really bad. We keep losing staff like every week someone else goes down.
It is different, all right? Like some treats you learn, like never go cheap when you're fixing your car. It never pays off. That's like the one thing you learn is all things.
All right, hi everybody. We're going to get started in a little bit. I'm going to ask the speakers to come up to the stage. Also, I want to give out a reminder that if you haven't done so already, please participate in our raffle. If you are a new and or young lawyer, you qualify for free registration for a 2-day conference next week, the Northwest DR Conference. So please do take advantage of this. We're giving out 4 free registrations. If you haven't registered, for those folks online, in the comment section, I let you know some instructions on how you can do that. But for any folks here too, please feel free to get in touch with me and we'll get you a raffle ticket.
We don't what? Hey, how you doing? Good, thank you.
Are you gonna go up there with wine?
No.
Feel free to move the chairs around.
Whatever.
I guess I will also meander curious surface.
Nothing.
The schedule.
The schedule for the
For this,
conference?
no, for this.
No,
Who's doing what in what order?
I'm not sure. I think, who's doing what in what order is the question.
Yeah.
Let me just ask you that. You're speaking on which issue? Or which
Tips and
seminar?
tricks for new lawyers.
Oh, that's right, okay. And you're speaking on?
Same.
Oh, you're the
Yep, we're on the panel.
Okay, so you two are, okay, so Alicia and I are gonna be talking about consumer arbitration
Yep.
law, and then I'm gonna be talking about the settlement conferences, for the disciplinary,
Right.
which is always a fun topic to people.
Oh, and I guess I've also got my session on, I guess we've called it judging mediators
Who'd
by
like,
their
who'd
companies.
like to start? Would you like to start?
We can start.
Okay, let's just start.
Okay.
You two can both have your own,
I know.
have your own mic.
Oh,
Let my
that's gonna scare me. I don't like talking to
So we're going to go ahead and get started. Thank you so much for coming. I expect there will be also people trickling in online as well as in person. This is our first in the series of membership events this year, this bar year. So thank you so much for attending. We're really spending today giving a preview of next week's Northwest Dispute Resolution Conference. We have very esteemed speakers today, all who are on our executive committee for the ADR section, and I'm going to let them go ahead and give introductions for themselves.
So Helen, do you want us all up here to introduce ourselves and then we'll start into our topics? Okay, great. Hi, everyone. My name is Adrienne Keith Wills, and I'm an attorney and mediator in solo practice. My practice area is family law. I also am collaboratively trained and do collaborative divorce, and I'm here in Seattle.
Hi, I'm Sasha Phillip. I am a full-time neutral mediator and arbitrator based out of Kenmore, but most of my mediations and arbitrations happen here. I am a former insurance defense litigator, and I jumped ship a few years ago and opened my own mediation practice about 2 years ago.
Hi, my name is Craig Bellis. I'm the chair of the Washington State Bar ADR section, and I'm a arbitrator and mediator. I'm currently a Fulbright specialist in peace and international conflict resolution, a former law professor from Gonzaga and a former assistant attorney general, amongst other things, including bartenders and auto mechanics and tow truck driving.
Hi, I'm Lishwitz, and I'm a past chair of the ADR section and a trial attorney and mediator and arbitrator in Seattle.
Okay, well, so Sasha and I are going to go ahead and kick things off this afternoon. At the conference next week, we are presenting on a panel that includes 2 other folks, Craig Smith and Mel Simberg. And the title of our talk is ADR Tips and Tricks for New Lawyers. And what we'll be talking about today is primarily the mediation component, and then our presentation at the conference will also include an arbitration component. So as I jotted down some thoughts yesterday in terms of what would be helpful today, I thought maybe it would be interesting to start with how I came to law practice in ADR. So I've been in practice now almost 12 years. I did actually start law school with an interest in ADR. I was a history major, and I was looking for something that I could do that would pay some bills and also help people. And I happened across an article in U.S. News and World Report that talked about how ADR was coming onto the scene, which I realize is probably even then a little bit of old news. But it was the first I had really heard about it, and it was really the thing that made me think this fits with how I want to practice law. That the emphasis is on problem solving, not winning so much, that you're looking at a dispute through a human lens, and that it's a gentler way to practice law, which, you know, one apprehension I had about applying to law school is lawyers burn out, and mental health issues, stress issues, all those sorts of things are endemic to the profession. I think even law students now are dealing with that, and so ADR struck me as a way to help people and have career longevity. So yeah, so I started law school and came out here, and most of what I do is representation, but I call them friendly negotiation cases. Maybe there's an attorney on the other side, maybe not, but my practice, and I guess my brand, if you will, is that I don't litigate. I mean, well, I should say, I don't hold myself out as a litigator. I do have cases where maybe we need to start to talk about that, but it certainly is not, when people read my website, when they hear about me, they're not hearing about me in that way. So that's about 80% of my practice. And I would say maybe another 10% of my practice is the collaborative divorce piece, and another 10% is as a mediator. So I do a little bit of mediation. I do much more work working with folks who are in mediation. So what Sasha and I have put together for our panel is some written tips and tricks, and we are going to kind of talk through some of those. You know, in terms of really basic pre-mediation preparation, you know, I think one of the things that Sasha and I both felt would be helpful for someone is to, you know, to really do some big picture thinking, that what does it mean to mediate in your case? What's going to set your case up well? You know, in some sense, if you were to have your ideal settlement document, what support, you know, do you need to create to achieve that outcome? And one tip that I got in law school that I think is probably pretty good universally is, if you are coming to something for the first time, ask a live person. So if you're in a practice setting where you know, you have other associates that you work with, or you know, partners, you obviously want to be thoughtful about whose ear you're bending, but that can be a way to get some more information. You know, I have seen posts to listservs asking for private responses about mediators, and you know, something that Sasha noted is you can also just call the mediator, and that can be a way to start to get some more information about how they work and whether or not they're a fit for your case. So in terms of practical stuff, what, you know, as you're thinking, okay, we are in this dispute, we are in this case, and you know, we're starting to consider how we want to resolve this, alternative dispute resolution being one means. You know, the first question is mediation timely? Is your case at a point where it is realistic to expect to resolve things in mediation? And that can vary widely from case to case and practice area to practice area. In family law, I think often if you see mediation, it's happening more toward the end of the case, and it's more of a settlement conference style, but it doesn't necessarily need to be that way. I had a case recently where, representing my client, we mediated final orders pretty much 90 days into the case, and it worked because it wasn't a particularly complex case, and all the information that we needed was there, and the parties were emotionally and psychologically ready to address that. So I would encourage you always to take a fresh look in terms of, is this the right time to mediate in a case? And obviously, it can be difficult if one party is really ready and another party is really not, but that's part of your three-legged race. And then, the second bullet point there is mediation appropriate? There are a lot of benefits to mediation, but if you have parties who, are simply not going to be able to reach consensus, or if there are novel legal issues, mediation may not be the right forum. So again, you have to think about your case. Mediation is a great tool, but it's not the tool that's going to fix everything.
Right. I'm just going to back up for just a minute and let you know what brought me to mediation. Unlike Adrian, I wasn't quite as, it didn't occur to me quite as early in my career that ADR might be the way to go. I went to college and was a psychology and political science major because I really wanted to go to law school. And then I went to law school because I wanted to do environmental law, public interest environmental law specifically. Unfortunately, there weren't any jobs in that area when I graduated, so I ended up in insurance defense litigation, which I loved for many years. But I had a case in particular. When people ask me what brought me to ADR, there's just one case that sticks in my mind. It was an employment discrimination case. It dragged on and on. I got brought in shortly before the scheduled trial date, and then the case kept getting continued over and over again. I filed summary judgment motions, kept narrowing the case for trial. And by the time we went to trial, we had tried mediation a couple of times during my tenure on the case, and it occurred to me that the plaintiffs were just so entrenched in their positions and so unable to move from those positions that they really hadn't left themselves an out. And we went to trial, and I got a defense verdict, which was great, but as Adrian was saying, it seems like there is a kinder, gentler way to practice law, and I think ADR really is that. So I did my basic mediation training back in 2006 or 7, and then I went back when I decided to quit litigation and did the basic mediation training again and did a practicum. And decided that really was what resonated with me. So that's when I decided to hang out my shingle and become a full-time mediator and arbitrator. And ask me again in about 2 or 3 years whether I'm able to make a living at that, because anytime you ask a mediator whether they're able to make a living mediating, solely mediating, the answer is, well, it depends. And I'm still exploring. But I definitely agree with Adrian that this is a gentler way to practice, and it gives you a lot of opportunity to interact with your client and actually figure out what their underlying needs and interests are, as opposed to just doing discovery because that's what you're supposed to do and running roughshod over their needs and interests. And one of the things, and this is actually under our bullet point number 2, is to prepare your client and your materials. And when we say prepare your clients, part of that is to sit down with your client and really have an in-depth conversation about what's going on, what brought them to the litigation, what it is they want out of the mediation, what it is that they want out of the settlement. And it may not just be about money, it may be about a number of other things. And if you can dig down to those underlying needs and interests and figure out what's really going on, there are a lot of creative things that you can do in mediation that you may not be able to achieve in a litigated setting. So one of the things we put up here is work backwards. Start with what you would like the ultimate outcome to look like. And work from there and figure out what facts, what legal principles may support that, so that you can then educate the mediator to what you're really wanting to get out of the mediation, and also have a conversation with your client about what's possible and what is not. And keep in mind that your clients probably have never been to mediation before, unless they're repeat customers and you've worked with them before, or they've had other lawsuits. They've probably never been to mediation. So they have no idea what to expect unless you let them know. So they're going to know a number of things, and obviously we'll talk about this more at the conference, but we have sort of a brief outline up there that you can take a look at. And work collaboratively with your client, because that's going to ensure, A, that you know what your client wants, B, that your client knows what to expect, and C, that you're able to work together at the mediation, because ultimately it has to be a collaborative effort if you're going to achieve the best possible outcome for your client.
Obviously, a big part of mediation is selecting your mediator. And we, have some bullet points. One question is, have you worked with this mediator before? I certainly know that as an attorney, it is easier to talk with a client about, well, I had this experience with this mediator, and so this is why I think they might be a good individual for your case. But if you're in a situation where, possibly the other attorney has proposed some mediators, and maybe their reputation does not precede them so much, there are ways that you can get some information to have a discussion with your client of, okay, we're proposing these folks, they've proposed these folks, what do we want to focus on? Many mediators do have websites. I think, certainly there probably is generally, I'm going to generalize here, an inverse relationship between the age of the practitioner and the likelihood of having a website. So I think Sasha is an excellent example of someone who's very active on social media as a mediator. That happens also with sort of varying degrees. So you're getting information from here and from there. And again, as I had said, you might be able to ask a listserv, or you might actually just want to call up the mediator and see if the things that they say, the experience that they have, seem like it could potentially be a fit. I think particularly if you have lawyers in a case, you probably are working with a mediator who probably has some legal background and some subject matter expertise. It's always worth considering to what extent that's going to bring value to a case. Maybe there is a situation where it is more about a relational dynamic, and so you don't need someone who has a deep understanding of, physics and, molecular biology. Conversely, if you are in an IP case, that might be exactly what you need. Subject matter expertise can obviously be, does someone know something substantively, but it can also be process expertise, that if someone knows, oh, this is the experience you might have if you litigate all of this, that can be really valuable too. And another question to ask is just, sort of, is the mediator a fit? One of the benefits of being in a large metro area like this is that there are a lot of practitioners. And so you don't have to just pick from one or two. That, if you have personalities in a case where having someone who's going to just sort of have more of a casually authoritative manner is going to be helpful, that's great. Or if you need someone who, maybe conversely is not going to raise anyone's hackles, that's important to take into account, because, certainly there are varying degrees of this, but you have humans in your cases, and they have all sorts of preferences, and so it's worth giving some thought to that too.
And I would certainly add to that, and you touched on this, Adrian, you can call the mediator. As a practitioner, I rarely, if ever, did that, but there's no reason you cannot call up a mediator that's been proposed by the other side and just interview them. Ask them what their subject matter expertise is, what their process skills are, what their training is, and have a conversation with them about the dynamics of the case. In fact, if you have that conversation, and a lot of mediators will do mediation conference calls or conferences as well to get a better feel for the case, because ultimately your mediator wants to help you achieve a good result for your client. And the more information you can give them and the more you can work with your mediator to educate them about the case and recruit their help, the better your likelihood of achieving that outcome that you've talked about with your client is going to be. So definitely don't hesitate to call the mediator, interview the mediator, email them, whatever it may be that you need to do in order to get the information you need to be able to make a decision whether to use that person. The next thing, obviously, is to select your mediation date, and there's a number of things that are going to play into that. If you have a case schedule, that's going to govern by when you need to complete ADR, which is usually mediation. You need to check with your client. You need to make sure that all the necessary stakeholders are going to be available. You can't just pick a date and assume that your client's going to be available. And you need to make sure that there's enough lead time before the mediation to gather all the information you need, do any discovery, take any depositions, and just have those in-depth conversations with your client. Maybe your client isn't quite on board. Make sure you schedule enough time to be able to meet with them more than once if you need to, or talk to them more than once if you need to, just to make sure that they truly are comfortable, or as comfortable as they're going to be with the process. And also to allow them to gather any materials that they may need to gather, or talk to any other people. If you've got a spouse, for example, who was in a car accident, they may need to talk to their husband or wife or other people in their family to be able to make an ultimate decision. Although they're the ones that are involved in the lawsuit, they might want input from other people. So make sure you give them enough time to do that when you select your mediation date.
Kind of part and parcel is you will, generally after you've set your mediation date, but this is certainly something you could request in advance, is the mediator's agreement to mediate. That gives you a lot of information about what to expect in terms of process on their end. It typically, either in a confirmation email or in the agreement itself, will indicate when the mediator wants the signed agreement back. If there's a deposit, when that would be due, when the mediator wants the materials, in what form they want the materials. And this is something where, in my cases, I've started to see some variation, that there are some mediators who are willing to accept things electronically. There are some who still have a preference for, if you hit a certain page number or exceed that they still want paper. And there can also be information there on scheduling and rescheduling in case situations arise.
And I'm getting the speed it up sign from our moderator. So I think I'll just summarize here. I mean, obviously, we've touched on sort of the very broad outlines of what we're going to be talking about at the conference. I would say if you want more information, come to the session. I believe it's session 1.1.
We are session 1.1.
First thing in the morning.
Bright and early Thursday morning, yes.
So we'll be talking about more in depth about the mediation part of this, but we'll also have two co-panelists, Mel and Craig, not this Craig, different Craig, who will be talking about arbitration. So it's essentially nuts and bolts on both mediation and arbitration. So please do attend that session if you're interested.
And I will add just briefly, there will be a role play, so it will not just be the four of us yakking. You'll have an opportunity to actually put some of this into practice, and there will be more war stories, so it will be more interesting.
Can I ask you a quick question?
Yeah.
So in terms of working with the client,
Hang on.
This is.
You need to talk into a microphone, otherwise the people online can't hear you.
So in terms of working with the client, I was just wondering, if the case does not settle, do you think it's helpful if the mediator kind of runs the client up the flagpole, like tests the client out? Like, is that helpful for an attorney to have a mediator test in front of the attorney how well the client's going to do, perform? Is that a service you think a mediator should be able to perform? Or what's your thoughts about that?
Well, I think part of a realistic assessment of your alternatives to settling are how well would this go in another forum, including trial. You know, I would guess, or my thinking is, as a mediator, and even as counsel, I would like to have an opportunity to connect about the idea of testing the client before the client just gets thrown into a sort of difficult situation, you know, before the pressure goes on. So I don't think that it's out of place, but I think that good practice would be that it's not something that just comes out of the blue, that there's a bit of coordination before something like that would happen.
And I would agree with that completely. I mean, that's one of the things that I think those pre-mediation phone calls can be very helpful for, is to have that conversation with the attorney and say, hey, you know, how much of this can I do with your client? How much of it do you prefer to do yourself? How much of it would you like me to do as the mediator? And if it comes to that point where the case isn't going to settle and it's apparent it's not going to settle, I might even ask the client, you know, is it okay if I talk to your attorney briefly, and then have that conversation with the attorney at the mediation about, you know, do you mind if I push a little bit with your client, just to make sure that when they walk out of this mediation without a settlement, they are prepared for what could happen next.
I thought you were going to.
First of all, I want to thank the three individuals who are on the podium here with me. These are all members of the executive committee of the ADR section, and it's a joy to work with them. The sessions that I'm involved in are basically a part one and a part two of the same general topic, and then an entirely separate session on settlement conferences in the disciplinary setting, probably one of your favorite topics to hear about. Something you want to stay as far away from as possible as one of the parties. But the first two sessions that I'm involved in occur on Thursday. First one's in from 10 to 11:15, and then the second part of it is from 11:30 to 12:45. Originated when I read three New York Times articles that you may have stumbled on back in the very beginning of November of last year, entitled Beware the Fine Print, which basically lambasted consumer arbitration clauses in consumer contracts and in employment contracts and other forms of contracts. And the New York Times, in my opinion, brought up many, many, many good points, but also had a very slanted opinion against such clauses. And of course, the problem that one has with these kinds of clauses becomes aggravated when you add to it a class action waiver, so that the consumers are unable to get together either in an arbitration or in a court of law. And Lisha is going to specifically address that issue in a minute. A very, very important issue. But this topic, I thought to myself, would be ripe for a lot of discussion and controversy. So I asked individuals whether or not they'd be interested in joining me on this panel. And Lish Whitson, who has a great reputation throughout the state of Washington as an arbitrator and mediator, amongst other things, advocate, agreed. Phil Cutler, who many of you have heard about, is on the panel. Mel Simberg is on the panel, as well as two retired judges, Puri Callis, who's now a judicial dispute resolution, and Terry Carroll, a former King County Superior Court judge, well known, who is now on the faculty of Seattle U. So we've got quite the powerful little panel that we're going to be discussing these issues. The first part of the discussion we're going to have, the first session from 10 to 11:15, it's going to start out, obviously after the introductions, with a short video by Robert Reich called In the Fine Print, where he agrees with the New York Times articles to a large extent, and perhaps even more so than the articles. And then we're going to highlight some of the many issues that the articles bring up with regards to the problems with these mandatory arbitration clauses. By the way, these mandatory arbitration clauses affect are probably legally binding in the United States in 1 billion potential transactions. They say on average, everyone over the age of 18 has at least 3 contracts that they've entered into that have these clauses in them. They're in almost all banking contracts, all checking contracts, all credit card contracts, your Comcast contract, almost every online click software contract that you enter into. Everywhere you look, these provisions requiring mandatory arbitration are present. And it turns out that very, very few of the disputes that arise under these contracts actually go to arbitration. When they do go to arbitration, they end up fairly fair in terms of how they're decided, but the percentage of them is ridiculously small. People who bring these matters up for fear and for various other kinds of handicaps that exist that make it difficult to raise these issues in an arbitration. So the article points out that there's the issues of the 7th Amendment right to trial that are being waived by individuals without really knowing it, waiver of class actions, bias and conflicts of arbitrators who do repeat business for the various corporations, secrecy of the proceedings and lack of precedent that you would have in a trial setting, the procedural disadvantages that you have in an arbitration, the lack of discovery or limited discovery, the lax rules of evidence, the fact that you have virtually no right of appeal, a number of those sort of things. So we'll talk about that briefly. And then I'll discuss probably the 3 primary Supreme Court cases that have permitted this kind of activity to become state of the art, become best practices as far as corporations are concerned. You've got the Concepcion case in 2011, the Italian Colors case in 2013, the DirecTV case in 2015. The first 2 cases, by the way, were 5-4 decisions in which Justice Scalia wrote the majority opinions. So the whole state of this law may be in flux, depending on what happens today. The DirecTV case was written by Justice Breyer, but it had more to do with statutory construction than it did with some of these underlying issues. Then I'm going to turn the matter over to Lish, and he will discuss these issues of waivers of class actions, and then of course we'll have a question and answer. But let me just briefly, before I turn it over to Lish, tell you a little bit about the second half, the second hour and 15 minutes. We have another video by Senator Franken, of Minnesota, who is also not enamored with these clauses at all. And it's entitled, "The System is Rigged." Then we'll talk about the current reality of some of the statistical work that's been done in this area. What are the facts? The AAA has done some research. The Chamber of Commerce, you can imagine which way they've tended. CPR have done research. So we'll talk about what the facts are as we know them, some of the statistics. And then the 2 retired judges are going to talk about the advantages and disadvantages of arbitration versus litigation. The whole part of the underlying theory of these articles is you're denied your day in court. Well, as you know, there are some issues with regards to bringing a $40, $50, $150 claim in court, not the least of which is the cost and the complexity. So there'll be a discussion by the retired judges, and then finally, after we do that, we will finish off with how to improve the situation, how to help out consumers in these settings. Is it judicial? Is it legislative? Is it at the federal level? Is it at the state level? Mel Simberg will be discussing those issues along with the rest of the panel, and then we'll take up the question and answers. But it has the potential to have the topic has been discussed over and over and over again since November of last year. There are more articles and more little, you know, listserv notations and whatnot that people have written about this. And the one thing that is if you get into this, that's really fascinating, is that most state courts are not thrilled about these opinions and are constantly looking for ways to get around them, to declare these mandatory arbitration clauses and these class action waivers to be unconscionable, either substantively or procedurally. And the Supreme Court has really said it's not easy to do, and they strike down a lot of these. Fortunately, if you're an advocate for the consumer, you're happy that the Supreme Court can't take every one of these cases up. So they remain the law of a circuit or of a state. Okay, having said that, Lish, I turn it over to you.
Well, Craig just said about 3/4 of what I was going to say. But
I'm sorry, Lish.
I've been mediating and arbitrating for more than 30 years, probably. Like Sasha, I started out in a firm that was focused on defense. But I always served as a mediator, and I tried to be fair to both sides. But perhaps having started when I did, I didn't consume the Kool-Aid to the extent that some of my colleagues who are now involved in ADR have. And I'm also a member of the American College of Trial Lawyers and the American Board of Trial Advocates. And I believe very greatly in the Constitution and the Seventh Amendment, which states, in suits at common law where value in controversy shall exceed $20. This was back in the 1700s. The right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. The Washington State Constitution states trial by jury, the right of trial by jury shall remain inviolate, but the legislature may provide for a jury of any number less than 12 in courts not of record, and for a verdict by 9 or more jurors in civil cases in any court of record, and for waiving of the jury in civil cases where the consent of the parties interested is given thereto. So that last clause would certainly apply to people that voluntarily enter into arbitration or mediation. Thomas Jefferson and Thomas Paine and others really held the Seventh Amendment to be perhaps more important than any other. Thomas Jefferson, in writing to Thomas Paine in 1789, said, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution." Alexander Hamilton, who is presently on Broadway, said, "The civil jury is a valuable safeguard to liberty." John Adams said, "Representative government and trial by jury are the heart and lungs of liberty. Without them, we have no other fortification against being ridden like horses, fleeced like sheep, worked like cattle, and fed and clothed like swine and hounds." And I would suggest that our current majority on the Supreme Court would be quite content with placing us in that position. You will notice that all of the cases that Craig is going to talk about are cases that have come about since we had a conservative majority on the U.S. Supreme Court. And that should be of concern to us, because the U.S. Chamber of Commerce and others who think that not having jury trials is a panacea against having quote-unquote runaway juries is quite sobering. I mean, it really is a frontal attack on the U.S. Constitution. Interestingly enough, from people who say they value the Founding Fathers and the original intent of the Constitution. It's just sort of mind-boggling what's happened. So I'm not adverse to ADR. I'm a proponent of ADR. I'm a participant in ADR. But I do not want the right to a trial by jury to be diminished or to be denigrated to some lower standard. I think it's an alternative. All of these are dispute resolution mechanisms, as is people just getting together and agreeing on things. So that turns me then to arbitration and the ethics of arbitration. As we all know, a neutral should in fact be neutral. That calls into question 3-member arbitration panels where the litigants pick the panel members. And so you have defense here, plaintiffs here, and some person who tries to be neutral in the middle. My suggestion would be that you can't really be an ethical arbitrator if you truly wear the hat of the defendant or the plaintiff in advocating for their position. If you're going to have a 3-person arbitration panel, and Craig and I have served on them for the AAA, I think they should be people that are simply 3 neutrals who are picked by some uninvolved entity. And I would urge all of you to think about that. There are other things that we should really think about. Med-arb, mediation followed by arbitration, is something that some people embrace. I question whether that can be ethical. If you held yourself to the same standards as a mediator who is now being asked to be the arbitrator that you would have at the beginning of the process if you were simply being chosen as an arbitrator, you would be disqualified. I was mediating a case for an international corporation against an employee of that corporation. And I thought the corporation, this was a woman who had spent 30 years as an employee, and she just wanted to know why she couldn't earn the same amount as her colleagues who were males. And that's what the dispute was about, and I thought they were appalling. But evidently I appeared to be neutral, and they asked me, they said, "Boy, we really enjoyed working with you. We'd like to have you as a mediator in a lot of cases." And I said, "No, you wouldn't." And I think that's the standard that we should hold ourselves to. There really are ethical concerns that we should all have. Craig has mentioned a couple of other ones when we talked, and I'm blanking on it right now. But there are a number of things where, for example, if somebody that is a party to a lawsuit wants to talk to you because he or she thinks that you're going to be their arbitrator, you know, that's fine for a mediator, and I agree with Sasha. That's something that probably due diligence requires, either of the mediator or the arbitrator. When I'm a mediator in a case, I try and talk with both sides before the mediation, not just to do what Sasha was saying about find out what your procedures are, but to find out what the facts are that otherwise I'm going to spend 2 or 3 hours at the beginning of the mediation sorting through and wasting their money. Why not do it in a casual phone call, one or the other, or even call both of them at the same time if they want to do it that way? In terms of giving a complete dossier of what you've done and who you are, I think you can be judicious about that. A guy that we both know well has something like a 6-page resume that he hands out to people when he's been appointed by AAA as a potential arbitrator. The last time he was on a panel with me, the litigants turned him away. They just thought, who is this self-important guy with all these 6 pages of stuff, some of which may cause problems if we really auger down into them. We'd just rather find somebody that has a 2-page resume and move on. So think about what you're doing. Be intentional in terms of what you're doing when you're going to be an arbitrator. And I guess the most important thing of all is just be as judicious as you think you would be if you were sitting on a bench as a judge. The standard should be no less, and you should require the litigants to be just as prepared, and hold them to the standard of civility that you would expect in a court of law. Sometimes people think because they're sitting in some office somewhere that it's not something where they have to be civil and professional, but certainly you set the tone and you can require that of them.
Thank you. As an arbitrator and a mediator, I try not to be biased, but I am biased about this topic. It's a launching pad for virtually everything in the arbitration field. Has been raised by these articles and the criticisms of arbitration. So I think we'll have a really good discussion over those 2 sessions next week. The other topic, and I will just take a few minutes talking about it, that I'm going to be addressing is in session 5 on Thursday, March 24th, from 4 p.m. to 5:15 p.m., just before the reception, is the settlement conferences with the state bar, ethical questions and ethical cases. This is a topic that has 1.25 ethics credits assigned to it. I think we have a quarter ethics assigned to our second part of the earlier issue, the New York Times issue. But this one is 1.25. And we have basically 3 individuals are participating in this. We have an individual who is one of the leaders at the State Disciplinary Office of Disciplinary Counsel, giving their perspective on this issue. Well, let me tell you what the issue is. The issue is, as of basically 2 years ago, the Supreme Court, under Justice Chambers at the time, encouragement, decided that in disciplinary matters, disbarments, reprimands, admonishments, et cetera, suspensions, that there should be a procedure for, quote, a mediation. Although we don't call it a mediation under the rules, we call it a settlement conference, but it is a mediation. It's a forced mediation, which seems a little oxymoronic, but so there's this procedure, and it's been in existence for 2 years, and I don't have all the statistics, but probably over half of the cases that are brought before the bar, disciplinary cases, are recommended as going to a settlement conference. The hearing officer who is assigned the case, and the hearing officers are all private attorneys. Lish was a hearing officer for years. I'm a hearing officer. We're assigned the cases, and we look at the case. We have our preliminary conference like you do in a Superior Court to set up the discovery and the timing and everything. But we also, at that hearing, make a decision whether we think this case is ripe for a settlement conference. And we put that in our order, our initial scheduling order. And then the chief hearing officer, who's another private attorney, a fellow in Seattle by the name of James Horn, a wonderful, wonderful man, appoints a separate individual. So you do not have the same person, of course, who is the settlement conference officer and the actual hearing officer. And that hearing officer, that settlement conference officer then takes over and sets it up like a mediation, sends out a settlement conference letter, which looks suspiciously like a mediation letter, in which you're informed of the confidentiality and the fact that what we expect from you in terms of submissions and individual caucusing versus joint sessions, that whole issue. And the reason why it looks like a mediation letter is it comes from my mediation letter, and we adapted it for the settlement conferences. And then, to make a long story short, we go into settlement conference. We set up time. Sometimes the individual attorney who's being disciplined comes in pro se. That presents ethical issues for the mediator, of yours. The Office of Disciplinary Counsel is there, and we conduct a settlement conference. And the questions that arise, and we're going to discuss a lot of the ethical questions, because again, on this panel is an Office of Disciplinary Counsel, a former head of the Office of Disciplinary Counsel who is one of the leading defense counsels now, representing respondent attorneys, Kurt Bulmer, and myself as a settlement officer. We're going to talk about a lot of the kinds of issues you're going to run into in those conferences, and they cross over. They're just the same kinds of issues to a large degree that you're going to run into in any mediation, with some issues exaggerated a little more than others. Like I say, the involuntary nature of it, the imbalance of power that you have to address as a settlement officer in order to keep things balanced. There are also many times issues of disability, whether or not the individual is competent to represent themselves, that you have to address. Getting back to the statistics, of about the 50% of the cases that go to settlement conferences, 50% of those are settled. So a good quarter or more of all the cases that come before the bar now are settled, which is a great savings from a very pragmatic point of view of resources and money. When we were first working on this, I'll give you a little bit of insight and I'll leave it at that. There are a lot of interesting little war stories that we'll talk about in the conference, but when we first started setting this up, I thought, oh, I don't like this concept of mandatory mediation in a quasi-criminal setting. It's almost quasi-criminal because they have the burden by clear evidence of proving that you've committed a violation of the RPCs, and now we're trying to negotiate a settlement, and I thought, well, there'll be a temptation on the part of the Office of Disciplinary Counsel to overcharge you so that they can negotiate back. And it hasn't turned out that way. There are a few supervisors at ODC who took the position that this should be done fairly and equitably, and I was amazed at how willing they were to settle these matters. Sometimes, and it's like any mediation. Sometimes it's just one little crazy interest that'll make the difference as to whether or not the matter will settle. And in a disciplinary matter, sometimes it's just the wording of the agreement that you come up with. The very, can we get rid of the word dishonest, and still permit a particular kind of discipline? Can we not? Can we agree that this is all going to be kept confidential and my minister is never going to find out about it? I mean, all those kinds of things, So we'll talk about those, and we'll talk about it from the perspective of the three major parties that are involved. Well, I won't have any respondents there, but I'll have respondents counsel there. So with that, I encourage you, if you're interested in that, to come by. I think you'll learn a few things.
So I'm going to interrupt. I think we have about 10 minutes left, and Sasha, you have another session that I'd like you to speak about as well. But I do want to say right now, last call for raffle. So for those online, for anyone here, if you're a new and or young lawyer, we have 4 registrations, free registrations for next week's Northwest DR conference. Right now, there's only 3 people who have signed up. So you have a very good chance of getting a free registration if you choose to sign up right now. So this is last call, and after Sasha closes up, we're going to announce the winners.
Well, that's going to leave you very little time, because I don't think I have 10 minutes worth of stuff to talk about. My second session, I believe, is session 2 on Thursday. So it's right after the session that Adrian and Mel and Craig and I will be doing. And it really is a little bit more of a sort of roundtable discussion. I met a mediator from Wisconsin at the ABA ADR conference last year, And we found ourselves talking about sort of the language we use as mediators to describe ourselves, to describe what we do, because there really doesn't seem to be any sort of uniform standard. The public doesn't know what mediation is, and depending on which mediator you talk to, they might describe what they do very differently. And the thing that started our conversation was my use of the term community mediator. And he took exception to that because he uses the word non-attorney mediator. And the reason I use community mediator is a very specific one, and that is because at a prior conference, I used the word non-attorney mediator to a mediator who works with one of the dispute resolution centers in one of the South counties. And she was highly, highly offended by my use of the word non-attorney mediator. And she said to me, you know, I don't define myself by what I am not. I don't define myself by the fact that I am not an attorney. I am many things, but not an attorney is not one of the categories I put myself in. So I started using the word community mediator, and Michael Rust, who is at the Winnebago Conflict Resolution Center in Wisconsin, he said, well, you know, I have a problem with that because some of my mediators, he runs a mediator cadre, I guess, they are in fact community, or they are in fact non-attorney mediators. They're not community mediators. They're not resolving neighborhood disputes and those sorts of things that you would consider community mediators to be doing. They resolve some fairly high stakes issues. So we started having this conversation. We thought, you know, this would be an interesting one to have a roundtable discussion about with both attorneys and non-attorneys who are mediators, and find out what the terms are that they use, what they're comfortable with, what words people are using to describe both themselves as mediators and the types of work that they're doing. So we'll just have a few sort of samples of language that we've come across and really open it up for discussion among the audience members to find out more about how people are using language in our field. So that's my very short description of session 2, and I don't remember what subsection of 2 it is, but you'll find it in the conference materials, and I think Craig brought a number of brochures for those of you that are in the room if you want to look up what sessions are when and make some choices about what you might want to attend, and sign up for the raffle. Thank you.
Do we have any questions? Online folks too.
Great. I have a question about mediation, arbitration, Lish. So what do you think about a mediation where the core of it settles, but like there are little terms about it that just aren't settling? What do you think about moving that into an arbitrator role to take care of the lesser terms of an agreement that generally settled?
Well, I know a lot of mediators just continue on. They call both sides, they keep kibitzing with one side or the other, and that's not really arbitration. They don't make the decision. They just keep working with the parties. From my perspective, and we're all talking just from our own, perspective, that's preferable. The problem that I have is if you turn it into something else, if you say, okay, we're no longer mediating, I'm going to be the decider, as our late president once said. If you change the rules of the game, you are clearly not a neutral in any sense of the word if you've already talked with both sides, heard both of their public and non-public positions on things. You may know secrets from one side that would torpedo the whole thing if you were, or might be the reason why you would rule the way you would as an arbitrator, and it wasn't part of the public discussion that you had back and forth acting as a liaison. So there are people who are firm believers in it. You should understand that my position is not the only position. I just don't think, I think it's fraught with ethical concerns as far as I'm concerned.
I could weigh in just a second on that. I agree 100%. In the settlement conference setting, the parties after the settlement conference, assuming it doesn't totally settle or doesn't settle at all, can agree to make the settlement officer the hearing officer. They can consent to that because they probably, their opinion might be, you seem fair, you already know a lot about the case, we can save time, we can save money, all those considerations. But as an arbitrator and a mediator, you have an obligation to the process. And I can tell you, I've been in the same situation that Lish has, where I've been through a day-long mediation or something, a settlement conference, and they wanted me to be the hearing officer. And if I could have told them how I really felt, they would not have wanted me to be the hearing officer because I was so biased against one party. By the time that mediation was over, that I couldn't be neutral and impartial. So I try to stay away from that as much as possible. Really scrupulous in that regard.
As a family law attorney and mediator, so many people cannot afford to do family law litigation. And when you've already invested in a mediator that has all of that information, and you've got the major things settled, it's not clear to me why one cannot make a waiver, even knowing they might lose on all the issues, because they're not going to be able to make it to trial, or whether it turns out one way or another, it doesn't matter. They can't afford it. They can accept a decision. I think about the situation where a judge has reviewed evidence that is not admissible, that may be completely out of line, and at the same time they've got to unring the bell and exercise their duty to make the decision on that which is admissible. So it's not clear to me why a mediator who is willing to serve in that role should not, so long as there's the waiver and full information. So that's in a family law situation where there may not be any other satisfactory remedy. Then I'm thinking it's not clear to me why mandatory arbitration would be inappropriate if there is a right to trial de novo, even if the losing party, or maybe the appealing party, one seeking a trial de novo, is responsible for fees if they don't prevail. As a practical matter, I don't think we can litigate everything. And so there may be a matter of scale how big of a case it is where this would apply, but it seems to me that the combination of waiving the right and having the right to a trial de novo might, it's not clear to me why that wouldn't get around the ethical concerns.
Well, when Craig said that mandatory mediation was an oxymoron, of course, we often have it in our superior courts anyway, where you're told you have to go and talk in good faith with each other. And of course, sometimes people are there in good faith, and sometimes they just say, I'm only here because I was told to be here. So that doesn't require a trial de novo. It just requires people to listen with hopefully open ears and gain whatever wisdom they can from a failed mediation, listening to the neutral as somebody who perhaps has some insights into what might happen. With regard to your first point, what Craig said I think is very important. We have to honor the process. And that's one of the things that I was talking about in terms of the Seventh Amendment. I think we have to honor the Constitution. If we don't, where are we going? And it's so strange that the people that want to take away the right to the Seventh Amendment are some of the same people that say they honor the Constitution and wrap it around themselves like a flag. But if you're saying that what you're saying sort of is the end justifies the means. People are over with it. They move on. It didn't cost them a whole lot of money. They didn't like the outcome, but at least it's over with. I don't know. That's a judgment call that people are going to have to make, and I don't know that finality should trump justice, if you could call it that. I don't know. The other panel members may have some insights I don't have. Adrian does it.
Well, I mean, certainly in family law, economics are an issue. And although there may be, for example, the settlement conference program, which enables folks to have a little bit of dispute resolution, maybe they've chosen something different, but having had cases where, something has come up at the end, I do think that there can be a benefit to getting some resolution, even if it is, I guess, what would be considered to be a decision. Technically, the mediator then moving into the role of the arbitrator. It's something that the parties, are aware of as an option and they've consented to. I think that having, like you said, if parties sort of feel that they're comfortable with the process, that can go a long way, even if they're not happy with the outcome. We obviously don't have mandatory arbitration rules in King County for family law, and I think we probably are. It would be hard for me to imagine that. But yeah, I commonly see in practice that mediators will have in their mediation agreement that to the extent disputes arise, they may be willing to arbitrate, and sometimes it is truly making a decision. And sometimes it's also just wrapping some stuff up. And so, I see what you see in family law. I don't really have another practice area perspective to bring to evaluate it from the standpoint of, say, justice, for example.
Well, I should distinguish, perhaps I now recall there are some agreements going in for MedArb, and I wasn't referring to that situation. It may not make a difference, but I'm referring to the more common situation I encounter. You have the mediation or the settlement conference, and it is later determined by the participants that they don't want to reinvest in somebody presenting all the evidence. They may not be able to afford to do that. They've got all that invested in somebody, and they say, I'm not going to get to court. I'm going to lose everything if I don't get these remaining issues resolved, and I cannot afford to go to court. They aren't really getting to realize their constitutional right because it's just not affordable. And so I would not view the mediator who agrees to serve as arbitrator of unresolved issues or implementation issues as doing something unethical when there's a knowing waiver by, especially by participants represented by counsel.
And I really do think that informed consent piece is the critical piece, that for folks to understand the trade-off that they're making, and there may be very good reasons to do it, as part of whatever that larger process is.
Yeah, I agree. You make a very important pragmatic, problem there. Where does the justice lie? Does the justice lie in keeping the roles separate, or does the justice lie in permitting the resolution at a minimal cost? It is a continuum, and you obviously do have to do everything you can as the mediator, if you're going to proceed, to get fully informed consent. The problem with that, of course, is that your role as a mediator has permitted you to become so intimate with the personalities and the various silent issues, if you will, that wouldn't ever be raised in the actual arbitration or trial later on. And what is your obligation? I mean, I had a case where after the settlement conference, I really, really disliked one of the parties. Not unlike the one that Lish mentioned. But both parties told me that they wanted me to be the hearing officer. What is my obligation in terms of full disclosure at that point? And how do I prejudice a party's case by fully disclosing? Or how do I prejudice by not fully disclosing? I hate you and I hate your case, and you're an SOB, you know? I mean, I can't very well say that. Although, that's what I'm saying, and that's what I would do. You're saying, I guess the assumption in your case is that you are not so biased that you don't feel like you could be fair. And you do have fully informed consent by the parties. That's a balancing act. And so.
Well, thank you so much. Join me in thanking all of the panelists today. Some chocolate. And so the winners of the raffle, we have online Carly Havens and Vanessa Ish, and in person we have David Hayawi. Congratulations. And for those in person, please join us for a reception.
Can you turn